Good morning and greetings from the great state of Oklahoma. I am honored to speak to you today, and I want to begin as Justice Gurich did by issuing a brief disclaimer that I'm not opining on any case pending before our court. But I do want to talk today briefly about the doctor-lawyer relationship in guardianship proceedings. I believe this is an area, of course, outside medical negligence, of course, the issue that conflates medicine and law, maybe second to medical negligence, would be guardianship proceedings concerning adults. And so today, much of what I will discuss will be centered on Oklahoma law and Oklahoma cases. And to our audience, although the cases I speak about will be specific to our state in Oklahoma, this area is similar throughout the country. And so I think we will use terms that will help you in your jurisdiction wherever you practice. As a practicing lawyer in my hometown for 20 years, one day I had the occasion to speak to my childhood physician who had practiced medicine in my community for over 60 years. Back in the day, in the late 50s, physicians were educated and went to small towns or communities throughout Oklahoma and practiced cradle-to-grave medicine. And I asked my doctor, what change have you seen the most in your medical practice? Of course, other than technology and advances in medicine, what has changed the most? And he said very quickly, without any reservation, when I came here to practice medicine, I rarely ever saw diagnoses of dementia or Alzheimer's. It was virtually unheard of. And now it is one of the most common issues that I deal with in my practice. He has since passed away, but that statement was really of great interest to me, because I also began to see in my legal practice the same issue. More and more issues concerning adults who become incapacitated mentally, such that it requires a proceeding to be taken to the courthouse. And I can also say, through experience, both in the private sector practicing law and now serving as a justice on the court, these cases are always difficult. In fact, they are some of the most difficult that judges face, and we will talk about that briefly this morning. Let me begin with the definition of a guardian, because it's a term that we use quite often, but maybe the definition is not readily understandable by some. A legal guardian is a person appointed by a court to care for the person or property of another. So a guardianship always requires a court order. It is different than a durable power of attorney, where an individual selects someone to act on his or her behalf. A guardian is appointed by a court, by a judge, after a hearing in a courtroom with all of the due process rights that are contained in a court hearing. The person that is appointed as the guardian and the recipient of that care is the ward. And so today, when we use that term, you will know what we're referring to. I want to talk about the requisites for establishing an adult guardianship in Oklahoma, but let's begin by what constitutes an incapacitated person. Under Oklahoma law, an incapacitated person is a person over 18 years of age. Now, what does that mean? It means that a 17-year-old or a minor doesn't have to be declared incapacitated, because the law does not treat them as having any rights to begin with. An 18-year-old in Oklahoma is the age of majority, and at that age a person can transact business on his or her behalf. So you have to be 18 and impaired by reason of mental illness as defined by the Oklahoma statute, intellectual or developmental disability as defined by the Oklahoma statute, a physical illness or disability, drug or alcohol dependency, or such other similar cause, and whose ability to receive and evaluate information effectively or to make or communicate responsible decision is impaired, such that the person lacks the capacity to meet essential requirements or is unable to manage financial resources. That is the definition of an incapacitated person. Oklahoma law also allows a guardian to be appointed for a partially incapacitated person, and a partially incapacitated person means an incapacitated person whose impairment is only to the extent that without the assistance of a limited guardian, the person is unable to meet the essential requirements for his or her physical health or safety, or manage all of his or her financial resources, or to engage in all of the activities necessary for the effective management of his or her resources. A lot of times we see the issues arise when elderly persons become exploited by those seeking to take advantage of their financial resources. I think it's important to note that there are duties that physicians have and others have in society that the law requires mandatory reporting of abuse. In Oklahoma, a physician is a mandatory reporter, meaning that a physician is a person who is required to report abuse of an elderly person, and failure to do so can constitute a misdemeanor. When is reporting required? Reporting is required when reasonable cause to believe that a vulnerable adult is suffering from abuse, neglect, or exploitation. I have seen cases that require mandatory reporting. Oftentimes it's not a physician. Sometimes it's a bank where they see checks coming through on an elderly person's account, and the banker knows that, or the teller recognizes these checks are not in the ordinary course of business of this person, and that will lead to a report that may find that abuse or exploitation is taking place. Exploitation means an unjust or improper use of the resources of a vulnerable adult. So it's mindful for all of us to recognize within our professions, are we mandatory reporters? Are we required to report these issues to the authorities? And physicians fall within that category. There's a case in Oklahoma case law where the court found that a particular proceeding did not constitute the appointment of a guardian because the individual was not found to be incapacitated or partially incapacitated. It's important to note what is the standard that is used to appoint a guardian. In Oklahoma, the standard is clear and convincing evidence. What that means is that if a guardianship action is filed in court, the judge will listen to the evidence, including the testimony of the witnesses, and must find by clear and convincing evidence that a guardian should be appointed. Now, what does clear and convincing evidence mean? In layman's terms, clear and convincing evidence means highly and substantially more likely to be true than untrue. Highly and substantially more likely to be true than untrue. And that is the standard that we employ at the trial level in Oklahoma to determine if a guardian should be appointed. Some of the cases that I presented go over the standards that a court will use to determine if a guardian should be appointed. And in the case of the guardianship of E.F. Bryan, this case concerns a gentleman who began later in life making transactions of his property that his family members didn't like. And he was suffering from some forgetfulness such that a guardianship action was filed in the district court. And in the cases, it tells us that Mr. Bryan adamantly testified at trial that he did not want or need a guardian. And that is typically always the case. Wards or prospective wards never want a guardian. Who would? Who would want someone to come in to their life and forcibly take over at the direction of a judge, their finances, all of their personal living decisions? Naturally, that's what we see. In this case, after the hearing and the judge listening to all the testimony, the trial court found that Mr. Bryan was neither an incapacitated person nor was he partially incapacitated, and he denied the petition to appoint a guardian. And the petitioner appealed that case in Oklahoma to the Oklahoma Court of Civil Appeals. And the standard on appeal, of course, is whether there is sufficient evidence to sustain the trial court's judgment. That's how the Oklahoma appellate courts look at the trial decision. The petitioner in that case argued that he produced clear and convincing evidence that Mr. Bryan was incapacitated, and as a result, he needed a guardian. In that case, the trial court noted Bryan did experience some short-term memory loss on rare occasions and did become slightly confused in the formal courtroom. Courtrooms do tend to confuse witnesses. That is not uncommon, but especially an elderly person that is more prone to be easily confused will likely be confused in a courtroom, and trial judges have to weigh this when they examine the witness. Remember, it's the trial judge who examines the witness's demeanor, the witness's behavior. And that is why there is such great deference to the trial judge as to the believability of a witness and to examine the evidence of the witness. Mr. Bryan was confused in the formal courtroom setting during questioning, but the trial court found that this in and of itself did not show a need by clear and convincing evidence that a guardian should be appointed for Mr. Bryan. And on appeal, the court found that the trial court's denial of appointment was supported by competent evidence. The next case, in the matter of the estate of Wallace, the issue was whether the elderly lady was partially incapacitated. And in that case, again, we see some transactions of her estate in the later years of her life that raised some questions. And a lot of times, a person will have a will have a document disposing of their estate for many years. And then as individuals become more elderly and maybe have some memory issues, they start deciding they want to change things. And so when the nephew decides he's not getting the farm, he is going to be upset. And these cases are this type of fact pattern is very common in these cases. In this case, Miss Wallace testified she had employed an attorney because certain people were trying to get her to donate $300,000 to the local industrial park. She did not know how much real estate she owned, and she did not remember selling some of it, and she had no idea how much money she had. Now, in this case, her doctor was subpoenaed to testify. And this is where we see the conflating of legal issues and medical issues. In a case where an individual has had a lifelong primary care physician, as is the case in many situations, the best witness for the judge to rely on most often is the treating physician. And in this case, Miss Wallace was a longtime patient of Dr. Bland. And so naturally, if you're a trial judge, who do you want to hear from? You want to hear from the doctor. You don't want to hear from the nephew that thinks Aunt is losing her mind. You want to hear from the doctor who has treated Aunt for 50 years. Dr. Bland, who had been Mrs. Wallace's physician for the past 15 years, took the stand after listening to her testimony and stated that she is a victim of what is commonly referred to as Alzheimer's or senile degeneration, and that she would not have been able to communicate to anyone the thought expressed in the dismissal letter that she had previously signed. And while her condition had improved, Dr. Bland opined she, quote, still is not totally aware of what was going on. In this case, the trial judge issued a bifurcated order, and that is an option to trial judges in guardianship proceedings. The judge can appoint a guardian over her person and a guardian over her state, two different people having two distinct duties. In that case, the order of the court was upheld. Moving on, guardianship findings. There are findings that are required under the law when a guardian is appointed. And this is also incumbent upon the trial judge to listen to the medical evidence in order to impose certain findings. The Oklahoma statute, and I will read from it, allows a judge to restrict a ward's abilities if he or she is subject to a guardianship. And in establishing the specific limitations on the legal activities of a ward for whom a guardian is appointed, the court shall the Oklahoma statute uses the word shall make specific determinations regarding the capacity of the subject of the proceeding. What capacity does the ward have? And again, what is the best evidence for a judge to make this decision? It's medical evidence. The judge shall make the following determination, including but not limited to whether the ward retains the sufficient capacity to vote, to serve as a juror, to operate a motor vehicle, and to be licensed or continue to practice any profession of the ward. Now, doctors and lawyers, what does that mean? That means if we are ever the subject of a guardianship proceeding and the court determines that we need a guardian, the judge in that finding should tell us whether or not we have the right to practice medicine or to practice law. This is required in Oklahoma. Also, the trial judge can make a finding as to whether or not an agent needs to be appointed to act on behalf of the ward, to enter into contracts, to grant conveyances, or make gifts of property. The reason is there are times when a judge would not want a ward selling any real property or making conveyances, and those are specific findings that we often see in a guardianship order. Now I want to jump down. I have 15 minutes. In the matter of the estate of Davis, we have a case where the trial judge did not make the findings that the statute required, and that is in your okay, in the matter of the estate of Davis, 2006 OKCIV APP 31. In that case, Hattie's primary care physician filed a report with Adult Protective Services indicating that Hattie was in need of care and supervision. And again, remember, Hattie's physician is a mandatory reporter, has a duty if Hattie is being exploited or abused to make that report. That is, I think, oftentimes a struggle for doctors because they have such a close relationship with their patients that to be involved in anything that the patient doesn't wish for the doctor to do can be a real challenge. In May of '99, a hearing was held for the petition to appoint a permanent guardian, and a different judge appointed a permanent guardian. After the judge was appointed the guardian, after that fact, Hattie executed a new will. The will was witnessed by another judge. Now, in Oklahoma, a ward can execute a last will and testament, which seems maybe counterintuitive. Maybe a judge has said to the ward, you can't vote, you cannot drive your car, you can't serve as a juror, but the law allows you to execute a will if certain findings are met. One of the requirements under the law is that if a ward executes a last will and testament, the execution of that document must be witnessed by a judge. Now, I want to get in on the next slide to testamentary capacity versus competency, which is a different standard in Oklahoma. How can a ward who has been declared incompetent, mentally incompetent, incapacitated, and in need of a guardian, how can a ward then execute a last will and testament? The case of the matter of the estate of Holcomb affirmed a ruling that the decedent possessed testamentary capacity. In this case, Miss Holcomb was 96 years old at the time of her death. Prior to her death, approximately 2 weeks after suffering a stroke, Miss Holcomb executed a will which divided her estate into fifths. Her 4 children were each to receive 1/5, and her daughter the remaining fifth. Now that sounds very common. 5 children each take a fifth. But as time progressed, 2 years later, she amended the will again, giving a little bit more to the daughter. And finally, as you might expect, 5 years later, and just a year before her death, she executed a third will, leaving her entire estate to her daughter. Now, do you think the sons are going to file an objection to that? They have been outed out of the will. And the issue before the court was, well, did she have testamentary capacity? What is testamentary capacity? It is the capacity determined by a court that a devotee, that a testatrix has the ability to execute a will. And that's just a fancy word or a legal parlance saying, do you have the understanding of what you're doing such that your will is valid? Testamentary capacity exists when a person possesses in a general way the ability to appreciate the character and extent of the devised property, understands the nature of the relationship between himself and the natural objects of his bounty, and apprehends the nature and effect of the testamentary act. Whether a person possesses testamentary capacity is a question of fact. I would present to you that there are cases in our jurisprudence that have found that a ward, subject to a guardianship proceeding, retained testamentary capacity. This language and the definition of testamentary capacity is on page 2 of the estate of Holcomb. And in that case, the decedent, Mrs. Holcomb, said that she left everything to her daughter because she was worried about her daughter's financial security. One of Mrs. Holcomb's nephews testified at trial that his aunt was, quote, sharp as a tack. And for the reasons set forth in the case, the court affirmed the ruling that the decedent possessed testamentary capacity. The next case, the matter of the estate of Carano, affirmed invalidation of assignment due to the assignee's lack of testamentary capacity. This is the opposite finding. In this case, the decedent had inherited an estate, and she assigned that inheritance to her local church. In May of 1988, at the age of 81, Dominique executed an assignment giving the entirety of the estate that she was to inherit from her sister to the Roman Catholic Diocese of Tulsa for the use and benefit of the Sacred Heart Church. That same day, Dominique also executed her will, naming the church as the chief beneficiary of her own will, and thus revoking her previous will, which had named relatives in the church as chief beneficiaries. And both assignments of the will were prepared by the church's attorney. This case gets into issues of undue influence, as we commonly see undue influence combined with testamentary capacity. Again, we have the review of mental capacity as it pertains to testamentary capacity, and we see the rule cited again. The rule holds that to have testamentary capacity, a person must know in a general way the nature and extent of her bounty. That is, in essence, the rule. Does a person understand the nature and extent of their bounty, what they own, and who they wish to give it to? The court found that the witnesses testified that in this case, Dominique was becoming forgetful around the time that she signed the assignment and about the time the will was prepared and executed. And we see the physician testified. And the physician testified that his patient had been on medication for memory problems as recent as the year before the execution. And we see that advanced age and reduced mental processes will not invalidate a gift where the donor is competent to understand the nature and effect of the transaction. But in this case, in weighing the evidence, the appellate court found that the trial court's judgment was against the clear weight of the evidence. All right, I'm going to move on now. We got five. We're getting close here. Lastly, I want to talk about the physician and psychotherapist patient privilege. At some point or another, a physician will be subpoenaed to testify in court. It's just the lay of the land these days. And it is interesting to understand what the privilege is that a physician has. I want to direct your attention to the case of Robinson versus Lane. It's an Oklahoma Supreme Court case from 1971. And I want to give the history, which is eloquently explained in this case, of the physician-patient privilege. And it's interesting to note that the physician-patient privilege was not recognized at common law. It was first recognized in the United States by the adoption of a statute in New York in 1828. The reason for the adoption of the privilege was to encourage full disclosure by the patient to his physician and to protect the patient from embarrassment by making secret his communications to the doctor. The issue in this case is when is the physician-patient privilege waived under the law? And what steps does a patient have to take to waive or to impliedly waive the physician-patient privilege? And the court instructs here that the patient waive the privilege such that the physician could testify because the patient testified about the ailment or disability, and that was the very subject of the case. By his own conduct, the patient, I'm paraphrasing, has made known to the jury and the public the ailment or disability he is suffering. After such public disclosure, there is no longer any need for the application of the privilege. We think the better rule, and the one required by the statute, is that the patient waive the privilege and the opposing party may call as a witness any physician who has attended to the patient for the same ailment or disability, the nature and extent of which the patient described in his testimony. In Holmes versus Nightingale, 2007, Oklahoma 15, we see, let me find that case and close with it. In this case, which is a more recent case from the Oklahoma Supreme Court, we see the issue of whether an individual who has clearly placed a physical or mental condition in issue by filing the suit, whether a court order allowing but not mandating oral communication with health care providers violates HIPAA's confidentiality provisions. In that case, the Oklahoma Supreme Court held that it is clear that the statutes preclude the general disclosure of all of a party's medical records and restrict discovery to the materials relevant to any issue in the action. And again, we see that builds upon Robinson, that the issue that the patient places as part of the issue in the trial, then the physician is allowed, as long as the court order allows, to testify without violating HIPAA. And your various jurisdictions may be more specific on that, and I would strongly encourage you to examine those as you look into the issue of a subpoena to testify, or maybe also to consult legal counsel to make sure that HIPAA is not violated. But the patient-physician privilege, as well as the attorney-client privilege, is very important to what we do and how we do it. And there are instances where it can be waived, and there are instances where it will be waived by a court. And in closing, let me just say that if you have not yet encountered the issues of elder law as a physician or as a lawyer, just wait. Or as a judge, just wait. It's coming. And as our society ages, these issues will be more and more prevalent in what we do, and they're very important to the well-being of our patients, to our clients, and to make sure that we ourselves are in compliance with the laws of our jurisdiction. It's been my honor to speak to you today. Thank you very much.